Chapter 20, Intellectual Property, How to Protect What You Create. Whether you realize it or not, your creativity may be one of your most valuable business assets. The products you invent, the artwork you design, the words you create, and the name and logo you use to represent your business all have monetary value. Under law, these products of your creativity are considered intellectual property and, like any other property you own, can be protected against theft or unauthorized borrowing if you take the proper precautions at the proper times. This chapter will help you gain a better understanding of how and when to protect your creativity. What is intellectual property? When you hear the word property, you probably think of things you own, like buildings, cars, televisions, jewelry, equipment, and other kinds of real property you can see, touch, buy, and sell. There is another kind of property, however, that may be even more valuable to you as a business owner. It is intellectual property. Property such as names, inventions, artwork, writing, music, computer programs, designs for products, formulas, processes, and anything else that results from creative endeavors. Just like any other property, intellectual property has value under the law and can be bought or sold. Unlike other property, however, the value of intellectual property lies in its unique and often in its reproducibility, in its uniqueness and often in its reproducibility. The design for a new product, for instance, may be used to produce hundreds of thousands of items worth millions of dollars. Thus, if the design is illegally copied and used to manufacture a similar product, the individual or company that created the original product can sustain a sufficient monetary loss. How is intellectual property protected under the law? The laws that can be used to prevent others from illegally copying and profiting from your creative efforts are called intellectual property laws. Among them are the laws covering copyrights, patents, trademarks, and trade secrets. These laws are specialized, often quite complex, and to some extent are being defined or redefined on a case-by-case basis as the law struggles to catch up with the information age and the technology that drives it. How does the various intellectual property laws differ from one another? The division lines aren't always cut and dry, but as a general rule of thumb, copyright laws help protect written, drawn, photographed, and artistic work. patents and trade secrets laws can help protect inventions, new machines, and new processes. Design patents help protect the way a product looks. Trademark and trade name regulations help protect the distinguishing identity of goods and services. Can a product be considered more than one type of intellectual property? Yes. Sometimes you can get protection for your intellectual property under more than one law. Jerry Elman, an intellectual property attorney and a partner in the law firm of Elman and Wolf in Media, Pennsylvania, says, for example, that some software embodies patentable ideas and can be protected by copyright as well. This, he says, is like having belt and suspenders protections for your property. What is a copyright? Copyright gives the owner of a work the exclusive rights to reproduce the copyrighted work, prepare derived work based on the copyrighted work, distribute copies or phono records of the work, to public by sale or transfer of ownership or by rental, lease, or lending, perform or display the copyrighted work publicly. Can I copyright my idea? No, you can't copyright an idea. Copyright protects only the means, words, a drawing, etc. you use to express the idea. It doesn't prevent others from adopting your idea and using it themselves. For instance, if you drew a picture of a uniquely shaped computer desk, you would own a copyright on the drawing, but your copyright on the drawing would not stop someone from actually building and selling thousands of desks based on your picture. Is there any way to protect ideas? You may be able to protect your ideas with patent or trade secret laws, which are explained later in this chapter. Can I copyright my business or product name? A name cannot be protected by copyright. You may be able to protect your name as a trademark, however. What can be copyrighted? The copyright laws cover original work of authorship that are fixed in a tangible form of expression. Among the types of works that can be covered by copyright are literary work, computer programs, which are classified as literary work under the copyright laws, musical works, including accompanying words, dramatic works, including accompanying music, pantomimes, and choreographic works, pictorial, graphic, and sculptural works, motion pictures, and other audio-visual works, sound recordings. How do I get a copyright? Under laws in the United States, work created on or after March 1st, 1989 is automatically copyrighted the moment you create it in a fixed form that others can perceive. What does fixed mean? Fixed is a tangible medium of expression, is a rather broad term designating a variety of material objects. Especially putting something into fixed form simply means putting what's in your head onto paper or disc or audio tape or some other format that others can read, see, or listen to. Among the things regarded as fixed formats are paper manuscripts, books, phonorecords, audio tapes, computer discs, sheet music, and films. Don't I have to register the work or put some kind of notion on it? Works published before March 1st, 1989 had to bear a copyright notice or the copyright was lost. Works published on or after March 1st, 1989 does not have to carry a copyright notice and don't have to be registered. Registering a copyright and putting a copyright notice on your work are both advisable. However, putting the notice on the work alerts people to your copyright claim to the work and identifies the owner and year of the copyright. Registering the work adds these advantages. It establishes a public record of your ownership of the work. It permits infringement suits to be filed. You cannot file an infringement suit until a work is registered. Registration made within 5 years of publication establishes prima facie evidence in court of the validity of the copyright and the facts stated on the copyright certificate. Registration made within 3 months after the publication of the work or before infringement allows you to collect statutory damage and attorney's fees if you sue for infringement and win. If the copyright wasn't registered before infringement, all you can collect are actual losses related to the infringement. Statutory damages are a penalty that can be levied in place or above the dollar amount of any actual loss. If I put a copyright notice on the work, how should I do it? The copyright notice normally consists of the following 3 things: the symbol @ the letter C in a circle, or the word copyright, or the abbreviation COPR. The year of your first publication, the name of the copyright owners. For phonorecords or sound recordings, the symbol P, the letter P in a circle, should be used instead of the circled C. Where do I put the notice? The notice should be in a place that gives reasonable notice of your copyright. The first page of a manuscript, the label of a record, somewhere in the front matter, traditionally the back of the title page of a book. If I want to register copyright, how do I do that? To register a copyright, you will need to send a properly completed registration form, non-refundable filing fee of $20, a non-returnable deposit of the work, to the Copyright Office. All 3 of those things must be in the same package. The requirements for the deposit of the work vary with the type of work being registered. But is it usually one or two complete copies of works that can be easily duplicated? To get application forms, information about deposit requires or other information about copyright. Write the Copyright Office, a Library, Congress, Washington, D.C. 20559, or call the office at 202-707-3000. I'm a freelance programmer and technical writer. If a company pays me to write a program or manual for them, who owns the copyright on the work I produce? You generally own the copyright on work you create as an independent contractor, freelancer, unless you sign an agreement assigning the copyright to your client. This, too, is a change from the way things were done in the past. It is a result of a 1989 Supreme Court decision and a case between Baltimore sculptor James Earl Reed and the Community for Creative Nonviolence, CCNV. Prior to that case, some companies hiring contractors to do work for them assumed they owned the copyright under work for hire provisions of the copyright law. And the case between Reed and CCNV, the Supreme Court found that CCNV's commissioning and supervision of Reed were not enough to make him an employee, and therefore work for hire rules did not apply. As a freelancer, he owned the copyright to his work. If you are not the only person working on the program or manual, the work probably would be considered a joint work, and you would co-own the copyright if there were no agreements specifying other arrangements. If I hire an ad agency to design ads for me, who owns the designs? Based on the Reed decision, the ad agency might be able to make a case for owning the copyright on anything it writes or designs for you unless you have an agreement stating otherwise. It would be a good idea, therefore, to have the agency sign an agreement assigning the rights in the work to you. If I revise a work, what year should I put in the copyright notice? The year of the original publication. Years in which the work was revised may be included too, but the significant date is the date of first publication. How long does copyright last? The copyright on works created on or after January 1st, 1978 is in effect for author's life plus 50 years. If the work is a joint work, the term of copyright extends until 50 years after the death of the last surviving co-owner. Works made for hire have a term of 100 years from creation or 75 years after publication, whichever is less. The copyright duration for anonymous and pseudonymous works is the same as that for works made for hire unless the author's name is revealed in the Copyright Office records. How long does it take to the Copyright Office to process registrations? It can take up to 120 days to get a certificate of registration, or if the application cannot be accepted, a letter explaining why it has to be rejected. If you want to be sure the Copyright Office received your registration package, send it registered or certified mail, return receipt requested. Do I need an attorney to get a copyright, or can I do it myself? Registering a copyright is just a matter of filling out some forms and sending the proper fee. So you probably don't need an attorney to register your copyright. However, if you are copywriting catalogs, advertising material, programs, or other works that were not created by you or one of your regular employees, you have to be sure you own the rights. See above. If you are copywriting computer software, you might want to consult an intellectual property attorney to determine if your program has patentable material and about how much of the source code might be considered a trade secret and can be blacked out when the source code is submitted to the Copyright Office for registration. Be sure to get Copy Office Circular 61, copyright registration for computer programs if you plan to copyright your own software. Similarly, if the work you are copywriting contains any kind of trade secrets or could be used in patentable items or processes, you should consult an attorney who specializes in these things. If I don't register the copyright, should I mail myself a copy of the work and save the sealed package to prove the date and authorship? That's a waste of time and effort. As attorney Jerry Ellman explains, it's a myth that you can date something by sticking it in the envelope and mailing it to yourself. That's because you could send an empty envelope to yourself, seal lightly with rubber cement, keep it safe, and then when the time comes that you want to annotate something, stick your newly created letter inside and seal the envelope shut. Instead, Ellman recommends having a friend with no interest in your work or notary sign and date your document as a witness, or better yet, simply registering the copyright. I publish a monthly newsletter. If I register the copyright, do I have to register each issue of the newsletter separately, or can I register a year's worth on one form? Since each issue is separately copyrightable, you have to register each one separately. A group registration is available, but it is for registering groups of works by the same author. Copyright Office Circular 62. Registration for serials explains the regulation for newsletters, bulletins, and other periodical. Circular 104. Group registration of contribution to periodical explains group registrations. I forgot to put a copyright notice on my program. Will I lose copyright on it? If the program was published after March 1st, 1989, no, you won't lose your copyright. It would be a good idea to add your copyright notice to future copies, though it isn't necessary. If the program was written after January 1st, 1978, or registered within 5 years of publication, the copyright may still be valid if you do your best to have a copyright notice put onto all copies that you can locate. Call the Copyright Office and ask for Circular 3 for more information. Do I have to give the Copyright Office a copy of the source code if I register my software? Do I have to give the Copyright Office a copy of the source code if I register my software? Not necessarily, but if you don't, you have to ask the Copyright Office for special relief from the script application of the law. They will respond with a letter saying that they can't determine whether there is copyrightable authorship in the materials you sent, but that they will issue a certificate under the rule of doubt. If you do provide at least some of the code, portions containing trade secrets material may be blocked out if you request another form of special relief. For additional information, get Copyright Office Circular 61. Is there any other way I can protect my software? You might be able to patent your software or use a trade secret law, trademark laws, or unfair competition laws to protect it. An intellectual property attorney would be the best source of information if you plan to market your software to a large commercial market. Can I copy phone listings? According to a March 1991 Supreme Court ruling in the case of Feist Publication versus Rural Telephone Service Company, you can safely copy the white pages in the phone book. In the decision that was handed down in the case, the court said copyright is not awarded for sweat of the brow work, but for originality. Listings in white pages of a phone book, the court ruled, are facts with no originality in organization or expression, and therefore cannot be protected by copyright. The ruling did not automatically negate copyrights on other kinds of compilations. It would seem from the wording of the decision that compilations showing originality of organization and expression would still be protected by copyright. What is likely to be tested in future court cases is just what constitutes originality of organization and expression. Can I reprint things I find in online databases? Generally, no. An online database usually consists of more than a listing of mere facts. Databases are usually specialized and involve some originality in selection, arranging, and often writing and editing. Thus, unlike the white pages in the phone book, their ability to be copyrighted would probably be upheld if challenged. I found a lot of information in an electronic library that I like to include in my newsletter. Am I allowed to do that since I paid to download them from the online service? No. The author of the text in the files you downloaded owns the copyright, and reprinting the file in your newsletter without his permission or his or her permission is an infringement of the author's rights. If I upload text or shareware to an online information service, do I give up any rights in my work to the online service? No. You wouldn't lose your rights in the work. You would still be the owner of your copyright. The service might claim a compilation copyright, which is simply a copyright on the particular collection of material available on the service. That doesn't take away from your individual copyrights in your work, though. You are still the sole owner of your work. I have a hand scanner and want to scan some artwork I found in a book and use it in my publication. Is that okay to do? If the copyright has expired on the book, or if the artwork included in the book is in publication domain, you should be able to scan in illustrations to use in your publication. If you are scanning from a new book of clip art or book that is collection of old Okay, so I have a scanner and I want to scan some artwork. I found it in a book and use it in a publication. Is that okay? If the copyright has expired on the book, or if the artwork included in the book is in the public domain, you should be able to scan an illustration to use in your publication. If you are scanning from a new book of clip art or a book that is a collection of old prints, look in the front of the book to see what the company says about reuse of the material in the book. What does being in the public domain mean? When a work is in the public domain, it means that the work is not covered by copyright protection. It can be used freely by the public without permission from the creator or his or her heirs. Among the types of work that are in the public domains are federal government publications and works for which the copyright has expired. In the past, some works wound up in the public domain inadvertently, too, because they were published without a copyright notice. Under the current law, however, copyright notice is no longer required on published works. A magazine wants to buy my craft design for reprint in the publication. The agreement with the letters they sent me reads, I hereby agree to sell all rights of the copyright. Does that mean I can't resell the design to a British publication? Yes, it does. By signing that agreement, you give up all copyrights in the material the magazine is buying. If you want to have the design published but don't want to sell all rights, you could try calling the publication and asking if they would be willing to change the rights clause. If you are unfamiliar with the rights that can be offered, check your library for books about selling writing. These books generally have information about the different types of publication rights. How much does a drawing have to be changed to be considered a new drawing? If I trace the outline and filled in my own details, could I sell the new design as my own? What you would be doing is creating a derivative work, and under the copyright law, only the copyright holder or someone the copyright holder authorizes may do that. Even if your design looked somewhat different from the original, if any of the author's expressions were copied rather than just the idea, you would be infringing on his or her copyright. What about fair use? How much of a copyrighted work can I reprint without getting permission? The answer depends on many factors, including your intended use. The fair use rule says portions of works may be reproduced for educational, news, commentary or research without infringement under certain circumstances. The circumstances are decided on a case-by-case basis using all four of the following criteria: the purpose and character of the use, including whether such use is of a commercial nature or is for non-profit educational purposes. The nature of the copyrighted work. The amount of sustainability of the portion used in relation to the copyrighted work as a whole. The effort of the use upon the potential market for or value of the copyright. In addition, there are numerous There are a number of more specific guidelines published for reproduction of text, music, and other works by educators and librarians. These are discussed in a Copyright Office Circular 21, Reproduction of Copyrighted Works by Educators and Librarians. Where do I get forms to copyright my work, and what do they cost? You can get the forms free from the Copyright Office. You pay $20 registration fee when you return the completed form. You can order them by phone calling 202-707-3000. Be sure to get the right forms for the type of work you are registering. The forms and what they are used for are as follows. For original registration, Form TX. For published and unpublished non-dramatic literary works, Form SE. For serials, works issued or intended to be issued in successive parts, such as periodicals, newspapers, magazines, newsletters, and annuals and journals. Form PA. For publication and for published and unpublished works of the performing arts, musical and dramatic works, pantomimes, and choreographic works, motion pictures, and other audiovisual works. Form VA is for published and unpublished works of the visual arts, pictorial, graphic, and sculptural works. Form SR is for published and unpublished sound recordings. For renewals, Form RE for claims to renew copyright in works copyrighted under the law in effect through December 31st, 1977, 1909 Copyright Act. Renew copyright in works copyrighted under the law in effect through. For correction and amplifications, Form CA for supplementary registration to correct or amplify an existing registration. For a group of contributions to periodicals, Form GR/CP for registration of a group or contribution to periodicals get filed in addition to application form TXPA or VA. How old do works have to be before I can assume they are in public domain? Under the copyright law in existence prior to 1978, the term of copyright was 28 years, and it could be renewed for another 28 years. However, the 1978 laws extended the renewal term on some works to 47 years, making the total term 75 years from the end of the year copyright was secured. Thus, anything published before 1918 would be in the public domain in 1993. If I copyright my work here in the United States, is it protected in other countries too? Many foreign countries abide by the same international copyright conventions that the United States does, and your work would be protected under their local laws if you comply with the provisions of the conventions. You can get a list of countries that honor U.S. copyright from the United States Copyright Office. If someone in another country infringes on your copyright, you would have to sue in that country. Trademarks and trade names. What is a trademark? A trademark is a word, group of words, name, device, or symbol used to identify goods you sell and distinguish them from similar goods sold by other businesses. It can consist of words, graphics, or letters, and is used to identify a product, line of products, or all the products produced by your company. A brand name like Coca-Cola or a symbol like the multicolor striped apple that identifies Apple computers products are both trademarks. Trademarks are service marks and protected under federal law. Can I trademark a service? Yes. It is called service mark. Is my business name a trademark? Your business name is a trade name. It is protected at the state or local level. If you open up a lawn care company called the Green Carpet Lawn Care Service, your next door neighbor couldn't open a business with the same name or one confusingly similar, but there would be nothing to stop a company in another state or, depending on your state laws, another part of your state from opening up a company with the same name, even if it was the same business. If you registered the name as a service mark, you could protect it from being used in other lawn care companies in the country. Something you might want to do if you want to franchise your lawn care service. If I want my business name to be trademarked, if I want my business name to be my trademark, do I have to register it locally and also register it as a trademark? Registering your business name is a state or local process and completely separate from registering a federal trademark. So if you want national protection for your name, you would have to register the name locally and apply separately for trademark protection. If you don't need national name protection, registering the name locally may stop other local businesses from using the name. If you want statewide protection for the name but don't need national protection, you could register a trademark with your state. Your Secretary of State's office should be able to direct you to the proper source of information for registering a name as a trademark in your state. Are there any restrictions on what can be used as a trademark? Your trademark or service mark can't be confusingly similar to others for a similar product or service, and it must do more than just describe a product or service. It has to give it a unique identity. You could not register the term lawn service as a trademark, for instance, but could probably register terms like lawn marker or green lawn if those terms aren't already trademarks for similar products and services. In addition, your trademarks can't be a generic term for a kind of product. Terms like photocopier or tissue can't be trademarked. Marks by Xerox and Kleenex can. In fact, you can lose your mark if it starts to be used as a generic term, as in Xeroxing a document or getting a Kleenex to blow your nose. Major corporations wind up spending a lot of money to keep the names of popular products from becoming generic terms. Should I invent a nonsense name and use something that reminds people of what the product or service does? Your choice of a trademark should be based on marketing factors as well as the ability to register the term. A truly unusual coin name will be far easier to protect as a trademark, since there will be little likelihood of there being similar names or marks in use. Xerox and Exxon are two familiar examples. A potential drawback of using a coined term, however, is that prospective customers may not immediately be able to identify the nature of your goods and might bypass your ads or sales literature. On the other hand, a name that is too descriptive of your product or service may present problems too. You may discover someone else is already using the clever name you choose, or that the name really won't be suitable if you expand your business in the future. Guided Message Center may be the ideal name for an answering service, but would it be inappropriate if you later decided to expand the business into full-fledged order fulfillment service? Thus, you might want to choose several possible names and test them out on friends and acquaintances and do some preliminary searches to see if they are already in use. If preliminary searches and feedback show the name sounds promising, then you can decide to search further if you want to use the name widely or just adopt it if it is not in use in your immediate geographic area. How do I get a trademark? If your mark is not confusingly similar to any others, you can acquire rights to it by using it in a commerce and continually to use it. If you can prove you were the first company to use a mark, you might be able to prevent others from using it, even if you have registered the mark. Even if you haven't registered the mark. Like copyrights, though, it is much better to register your mark. What are the advantages of registering a trademark? With federal trademark registrations, you could gain nationwide protection, and if your mark was infringed, you could get federal court orders to prevent continued use of the mark. In addition, you might be able to collect money if sued and won. Is there anything I have to do before I start using my mark? Before you start using your mark, you should do a trademark search to be sure no one is already using it. I'm only going to sell the business in my state. I'm only going to sell to businesses in my state. Do I have to do a national name search, or can I just do a search of local business names? If you are only going to be providing services locally and won't be investing a lot of money in name recognition, a local search may be sufficient. Searching the Yellow Pages listings, county and state business name listings, and ads for products or services similar to what you sell will probably be sufficient to tell you if there are companies marketing services in your area with confusingly similar names or logos. Be aware, however, that if your name should conflict with similar products, so naturally you could be forced to stop using your name if theirs existed first. Similarly, if you later expand to other geographic regions, you might run into name conflicts you didn't discover on a local search. When should I do a search in a wider geographic area, and how would I do it? How extensively you should search will depend on available funds, time constraints, and the relative importance of making sure there are no conflicts. If you are going to sell products to offer services more widely and invest more money in name recognitions, then a more extensive trademark search is warranted. Your best bet for doing a national search is to hire an intellectual property attorney or a trademark search firm or information broker familiar with doing trademark searches. If you want to do the search yourself or do a preliminary search before retaining an attorney, there are several electronic databases that will simplify the search process. The primary ones are Thompson and Thompson Trademark. Thompson and Thompson's Trademark Scan, Federal and Trademark Scan State, which lists trademarks registered at federal and state levels. Both of these databases are available on Dialog and have gateways to make them available from CompuServe and Genie. Since not all trademarks are registered, other directories and databases should be searched as well. Don's electronic business directory, available on CompuServe, is useful since it contains names, addresses, phone numbers of over 8.5 million businesses and professionals in the country. Yellow Pages and industry directories available in public libraries are valuable search tools too. The Patent and Trademark Office in Washington, D.C. has a library that is open to the public. See page 473. In addition, there are public and university libraries throughout the country that have been designated patent and trademark depository libraries. These libraries have copies of patents and federal trademarks, records you can search to get information about the patent and trademark and patent and trademark depository libraries. The libraries have copies of patents and federal trademark records you can search to get information about the patent and trademark depository libraries. Call the Patent Trademark Office at 703-308-3924. If I hire an intellectual property attorney or trademark search company to do the search and they don't find anything similar, can my trademark be challenged? Yes. Your mark, even once it is registered, could be challenged as being merely descriptive for up to 5 years. Additionally, while an attorney or search firm is likely to do more extensive and knowledgeable search than you would on your own, there is no guarantee they will turn up all unregistered uses of your mark. Your mark, even after it is registered, could always be challenged by a prior user of the mark. If your mark starts to be used as a general term to describe a class of products, you could lose your right to it as well. Aspirin and escalators are two examples of products that lost their trademark because they became generally accepted terms for describing a class of products rather than the product of a specific company. What does it cost to register a trademark? The federal filing fee for registering a trademark is $200. If you have intellectual property attorney to do the search for you and prepare the application, you could plan on paying an additional $700 to $2,500 in addition to the filing fees, depending on the extent of the searches done, the result of the searches, and the attorney you retain. Be sure you ask about fees in advance if budget is a major consideration. Must I have an attorney to register a trademark? No, you don't need an attorney to register your trademark. Depending on your plans for business or product, it may be advisable, however, the extra fees buy you better searches, unless you happen to be an expert at electronic searches and other search techniques, as well as the attorney expert judgment on whether or not the mark could be considered confusingly similar to others in use for the kind of products or services you sell. Whether retaining an attorney or registering your trademark are worthwhile at all will depend on your budget and plans for what you sell. I have a trademark I want to use, but I am not ready to start the business. Is there a way I can keep others from using the mark? Yes. A 1989 amendment to the trademark law allows you to reserve a trademark you intend to use by filing a special form and paying a $200 fee. When do I use the trademark symbol? When do I use the circle R? If you are claiming trademark rights and haven't registered the trademark, or registration hasn't yet been approved, you would use the symbol TM to denote your claim to a trademark, or SM to denote a service mark. Once registration is granted, you use the symbol R, circle, to denote the registered trademark. How do I protect my trademark? To protect the trademark, you have to continue using it, and you have to keep it from becoming generic term to describe a class of products. To maintain the distinction, your mark should be used as an additive, as an Band-Aid adhesive, bandages, or wordsmith writing services. To further protect your mark, you should make sure it is always printed in the same way, and that your trademark notice is used at least once in each printed piece containing your mark. How do I actually register the trademark? To register the trademark, you need to submit the patent or trademark office a written application, a drawing of your mark, and 3 samples of labels, 3 of a label or other examples showing the mark in actual use. You can get the application form and instructions by writing the U.S. Patent and Trade Office in Washington, D.C. 20231. Mark your envelope trademark information requested, or by calling 703-557-3158. If you have questions about trademarks or patents, call 703-308-HELP. What if another company starts using my trade name or mark? If you decide it is worth the cost of fighting the unauthorized use of your name or mark, you should contact an attorney. If you've registered your mark or name, he or she will send the company a letter demanding they stop using the name. If you haven't registered the name, the attorney can help you find out if you have common law rights to the name through the first use, and if it's worth the time and cost to pursue the matter. Does a U.S. trademark give me any protection in foreign countries? No. If you want trademark protection in other countries, you will have to determine their laws and apply there. How long does trademark protection last? Trademark protection can last independently, however. To retain trademark registrations, you will have to file an affidavit between the 5th and 6th year of use. Saying you are still using the trademark. Additionally, at the end of the 10th year and every 10 years thereafter, you have to renew your registration. Does it cost anything for the affidavit or the renewals? Yes. There is a $100 fee when you file an affidavit and a $300 fee each time you renew the registration. It sounds like a lot of work and money. Should I bother? That is a decision only you can make, and it should be based on your budget and your future plans. If you plan to stay a small local business, it probably isn't necessary to go to the time and expense of registering your name as a trademark. If you expect to grow and sell in wider geographic areas, it may be very worthwhile to apply for trademark registration. Patents. What kinds of things can be patented? Patents are granted in these broad categories: products, machines, processes, compositions of matter, major variation of existing products, processes of or composition of matter, new variety of plants, new or original designs from manufactured item design patent. What makes an invention qualify for a patent? To qualify for a patent, an invention has to meet these qualifications. It must be new, which means it can't be patented or described in a printed publication in any country. And it must not have been used publicly or placed on sale in the United States. It must be useful. It cannot be something obvious to someone having ordinary skill in the relevant technology. How does the Patent Office interpret the terms obvious and ordinary? How can I tell if my invention is obvious? That's one of the sticky parts of patenting inventions. Explains intellectual property attorney Jerry Ellman. If you've got more than ordinary skill, what's possibly obvious to you may not be obvious to someone with ordinary skill and may be legally patentable. If you've got a good idea, talk with a patent attorney if you think it's a moneymaker. Is there anything that can be patented? Printed materials, general business ideas, methods of doing business, scientific theories, mathematical formulas, useless devices, and obvious changes to existing devices cannot be patented. How do patents differ from copyright? A copyright protects the form of expression of an idea. One specific drawing, one set of words, etc. To get a copyright, your work only has to be original. A patent protects the conceptualization of an idea and has to be not only original but also not obvious. For instance, if Thomas Edison had copyrighted a written description of how to make a light bulb, no one would be able to reproduce his description without his infringement on his copyright. However, people could have used his description to make their own light bulb. By patenting the light bulb, Edison prevented others from manufacturing and selling the light bulb unless they license the right to do so from him. What rights does a patent give me? A patent provides new and original inventions or processes from being copied, produced, or sold in the United States and its territories and possessions. It gives you the right to prevent other companies from making use or selling your invention and the right to sue if anyone infringes patent as defined by the claims. In other words, if anyone copies or uses or sells your invention without your permission, a patent makes it possible to get a court order to stop an infringement and to sue for and be awarded money for past infringement. Does a patent give me the right to sell my invention anywhere in the United States? No. There's a common misconception. A patent does not give you any right to sell your invention. It only gives you the right to stop others from selling it. The right to actually sell your products may be controlled by the FDA or some other regulatory agency, or could be limited by existing patents. Suppose, for instance, you fiddle around with one of the pocket electronic organizers and devise a way to make a new plug-in card that will let the pocket organizer double as a remote control for the TV and a garage door opener. You might have a patentable invention, but might not be able to sell the invention because of prior patent on the machine and or its plug-in cords. How do I find out for sure that no one else has already patented my idea? You should search industry publications and catalogs that have a search of patent office records done to determine what patents might exist for inventions similar to yours. Where can I do such a search? You can search the patent records at the Patent and Trademark Office in Washington, D.C. See page 473. Or you can search records in the PTO depository libraries located throughout the United States. How long does a patent last? Patents on inventions are good for 17 years from the date the patent is granted, provided you pay a maintenance fee due 3.5, 7.5, and 11.5 years later. Design patents are granted for 3.5, 7, or 14 years. Can a patent be renewed? No. When the 17 years are up, anyone can use the invention, unless the patent is for a drug that has gone through the FDA approval and has been extended by the Patent Term Restoration Act, or unless the patent is extended by a special act of Congress. When do I file a patent? If you plan to patent an invention, do so as soon as possible. A good idea is, as long as you can describe the invention in enough detail to enable someone else to make and use it. In the United States, you have to apply for a patent within 1 year of the time you first disclose the device or start selling it. In other countries, you may have to apply for the patent before it is publicly disclosed. Since disclosure includes showing your plans to others without first making them sign a confidentiality non-disclosure agreement, it is a good idea to get a non-disclosure agreement signed by anyone you show the device to before it is patented and make marketing decisions early on. What does the Patent Office charge to patent an invention? The Patent and Trademark Office fee depends on the number of claims in the patent application and the size of the company filing for the patent. The minimum fee is $355 for small businesses and $710 for big businesses, and covers applications with no more than 3 independent claims and no more than 20 total claims. Do I need an attorney to file for a patent? You will very likely need the services of an attorney or a patent agent. Patent agents don't have to be attorneys to practice before the U.S. Patent Office, but they do have to be technical training and have passed a difficult exam. While you are technically not prohibited from submitting an application yourself, it is usually foolish to try to do so unless you are very well versed in patent law. In fact, a form letter the patent office sends out to inventors whose applications are rejected reads in part. An examiner. Oh. Okay. An examination of this application reveals that applicant is unfamiliar with patent prosecuting procedures. Patent prosecuting procedures. While invention may prosecute the application, lack of skill in this field usually acts as a liability in affording the maximum protection for the invention disclosed. Applicant is advised to secure the services of a registered patent attorney or agent to prosecute the application. Since the value of a patent is largely dependent upon skillful preparation and prosecution. Furthermore, an attorney can help you plan the right strategy for your purposes, explains attorney Jerry Ellman. The first thing to think about is, why do you want a patent? Is it because you are about to sell a product and want to make sure nobody else can ride your coattails in the market? Or is it because you have an idea for a product and want to sell this idea to some company that would make and sell products, paying you a fee for each one sold? Or do you want to be able to say you have a patent pending so that investors will fund your business? Or do you just want to put it on your resume and your who's who listing? These different motivations would give you rise to differing strategies and expenditures of time and money. How much will it cost me to have a patent attorney file the application? If you do retain a patent attorney, expect to pay $2,000 to $6,000 or more if your invention has potential for significant profit. This would be money well spent, since the value of your patent could hinge on the way the patent claims are written. Where do I find a patent attorney or agent? Look. Look in the yellow pages of your phone book under the patent or under the law listings. You can also give a list of agents registered to practice before patent office from the superintendent of documents government printing office. See pages 472. While you may file a patent without using an agent or attorney, anyone else who prepares your application must have passed the patent office examination and must be registered to practice before the patent office. What about companies that say they will patent and market your products? Are they any good? Some are better at marketing their services than marketing their other people's products. Check around carefully before using one of these groups. Try to find other inventors and ask what their experiences have been and who they know to be truly helpful. If you can't find any inventors, organizations, try calling local SCORE, the SBDC, SBA, see Appendix 2 for addresses and information. Or university or college business school offices and ask for references. There is also a magazine for inventors called The Dream Merchant, where you can get marketing information for your invention. The magazine maintains a database of invention groups around the country and provides referrals for subscribers. For information about the Dream Merchant, write the magazine at 2309 Torrance Boulevard, Suite 201, Torrance, California 90501, or call 310-328-1925. When I file a patent, can I leave out information that is a trade secret? No, you must disclose your invention to full so that anyone of ordinary skill in the relevant technology will be able to make and use the invention. How can I see if there is interest in my idea and protect it from being stolen by the manufacturer? The best way to patent your invention before showing it to manufacturers. The best way is to patent your invention before showing it to manufacturers. Can I patent a variation of a product? Only if the variation is not an obvious change. In addition, if your variation is patentable, the patent's only the original invention. If they have not expired, might prevent you from selling your invention without the consent of the inventor. Can I patent a variation of a product? Only if the variation is not obvious change. In addition, if your variation is patentable, the patent's only the original invention. If they have not expired, might prevent you from selling your invention without the consent of the inventor of the original item. Can I patent a novel idea for using existing products? Only rarely. The idea would need to be unobvious process to be patentable. Will the patent I get in the United States protect my invention from being copied and used in other countries? No. You will have to file patent application in the foreign countries in which you want protection. Remember, too, that you usually must make this application before any disclosure of your invention has been made. You do not get the year's grace period that you do in the United States. What happens if someone does infringe my patent? As stated previously, you have the right to sue and could be awarded money for past infringement. However, suing can be a lengthy, expensive process, pitting you against the money and legal staffs of giant corporations. If you are determined and have a valid patent, you might win the lawsuit in the long run, but the monetary and emotional costs can be draining. It took Robert Kearns, the invention of the intermediate windshield wiper, 12 years to win his battle against auto companies for infringing his rights. Eventually, he won $10.2 million settlement, $8 million of which went to legal fees. and was planning to use the remaining to bring still more infringement suits. It is possible, however, to get patent owners insurance to pay an attorney's fee for such suits. How do I protect the idea for an invention? If you are working on an invention and want to document your process, the dates of your work could have your log signed and dated by a notary or friend who is not involved in any way with an invention. I have already started to market the product. Can I still get a patent? In the United States, you can apply for a patent within 1 year of the time it first offered for sale and disclosed publicly. So if you have been marketing the product for less than a year, you may be able to get a patent in this country. Other countries require you to apply for the patent before disclosing your invention. Thus, you cannot qualify for patent protection in those countries. How can I protect a design for a new product? There is something called a design patent that lets you protect your things such as designs on jeans, the shape of an object, and other designs used in manufacture of goods. What is a non-disclosure agreement and when do I need to use one? A non-disclosure agreement prohibits others from using your confidential information or trade secrets for their own benefit or divulging that information to anyone else. You would use one if you have employees who have access to confidential information such as your customer list or plan for an invention, or if you have to show confidential information to others outside the country. What is a trade secret? A trade secret is business information you have that gives you a valuable edge over your competitors. This information may be a recipe for a cookie, an invention, the unique part of the code for a program, your customer list, plans to introduce new products, or almost anything else that is generally not known and gives you a competitive advantage. What kind of protection is there for trade secrets? If what you have is not generally known, and if you have taken care to maintain secrecy, you can sue the individual who disclosed your secrets. You may also take legal action to stop use of your trade secrets by others and recover damages if unwarranted. What do I have to do to maintain secrecy? Generally, you have to limit access to what you consider a trade secret, be it your customer list, your recipes, or formulas. If you need to give people access to your trade secrets, you should make them first sign a non-disclosure agreement, preventing them from using or passing on what they learn. If you have employees, don't leave important papers laying out on desks or in unlocked drawers where someone working late could easily get at them. Avoid giving suppliers or bankers or anyone else your deal with access to your trade secrets too. How can trade secrets laws help me? Trade secret laws can protect your invention or your software or in the development stages and can help you prevent others from profiting from your business, procedures, lists, processes, and other unique parts of your operation. Some companies that have products with short lives or short budgets take their chances on trade secrets and speedy commercialization rather than go to the expense and time to apply for and get a patent. However, if a company develops on their own what you don't have a patent, you have no recourse against them. Read that again. How can a trade secret law help me? Trade secret laws can protect your invention or your software in the development stage and can help you prevent others from profiting from your business, procedures, lists, processes, unique parts of your operation. Some companies that have products with short lives and short budgets take their chances on trade secrets and speedy commercialization rather than go to the expense and take the time to apply for a patent. However, if another company develops on their own what you have, if you don't have a patent, you have no recourse against them. Okay. What is licensing and how does it work? Licensing allows you to make money from other people's use of something you have created or you own. For instance, when you license a design you have created or a software program you have authored, you give the license the right to use that work under specific circumstances that are spelled out in detail in a written agreement. The agreement will usually specify such things as how, when, and where licensee may use your work, how you will be compensated for the work, and whether the licensee has exclusive and non-exclusive rights to use your work. Can an attorney help me with patents and other intellectual property? Only a patent attorney or a patent agent may represent an inventor applying for a patent. An attorney in general practice often won't have the background and experience in intellectual property law to help you protect or defend your rights to intellectual property. If the matter is something more or less routine, like registering a copyright, a general practice attorney may be able to process the paperwork. In all probability, the attorney will job out the routine paperwork to a firm set up specifically to handle it. He or she probably won't have the expertise to counsel you on how an intellectual property law, such as copyright law or patent law, relates to a specific situation and how that situation is generally handled, contracts, and in court. Your best bet is to locate an attorney who specializes in intellectual property and is familiar with your industry. How can I find intellectual property attorney? Intellectual property attorneys are sometimes listed as patent attorneys in your phone book. If you can't find one who knows your field, call the bar association or a trade association and ask for a recommendation. If you are in the art, music, painting, writing, for example, you can get information and referrals by contracting the volunteer lawyer for the arts. If you can't find a branch of volunteer lawyers for the arts in your phone book, call the main office at 1 East 53rd Street, New York, 10022, 212-319-2910, and ask for information and a reference to a branch near you.